gentlemen, on the 6th of January, 2023. We have a live stream up, and we have Judge Hurley and myself here in the state capitol. Staff Attorney Sarah Behrens running the show via Zoom. And let me go touch the button on the screen. Judge Clark and Judge Elduik appearing remotely. And Judge Madsen indicated he might be late because he had a lot of hearings stacked up late morning. So we will begin. Ms. Behrens, you circulated a tracking worksheet and some other materials this week. I'll just turn it over to you to kind of take it through what you've experienced so far this week, and then we can talk about what's coming up next week and any decisions to make.
Okay. So 4 of our bills were up. And so we had 1041, which was the restitution bill, which we'll need to talk about.
Maybe take that last.
Okay. Let me go back to my hearing schedule. Okay, so we had 1058, which is the small claims bill. And I think there might be an amendment coming with that one. Chair Clamine had indicated that he thought that it should be worded differently to carry that the plaintiff gets the fees going through the appeal, because the way it's worded now, either party would get attorney's fees, and he thinks it should be a shall. So I'm not sure what they'll do with that one. But
I would agree with that.
so I think that'll be getting tweaked a little. Then the disclosure of pending decisions. I think you all saw that one failed.
What did they say? What was the reasoning?
That they didn't feel it was necessary. They understood why we had put it in, but they did not feel that it was necessary since it has never happened here.
First leak is free.
Yes.
Okay.
So they thought that we should have policies and personnel rules that should take care of it.
Jack McDonald testified. He represents the newspaper associations and makes sort of free speech, free press type arguments, and that's the way it goes.
They were a little hard on him, though.
Oh.
Can I just ask a question? Did they ever find a leaker for the United States Supreme Court one? I haven't followed that. Did they find who did that?
They haven't announced anything about the investigation.
Okay.
Okay, then we also had the summary disposition and dismissal bill up, and that one passed. That's got a do pass recommendation, no issues there. I also watched the spousal support bill. So there were 2 that were put in that were the same bill, but with different application. I think the one is being withdrawn because the hearing was canceled.
The one with
in the Senate. Yep.
Okay.
So I'm thinking that one is not going to move forward, but I'll let you know if that changes. Let's see. There were some concerns expressed with the spousal support bill as written, so I think they're going to tweak it a little bit. It was kind of around the whole permanent spousal support and whether it should specifically state that permanent spousal support is not allowed. Attorney Pladsen thought that would lead to more motions, trying to amend old permanent awards, even though the last section in that bill makes clear that it's not retroactive. So, but that got a due pass. So we'll see what happens with that. Then see if there's anything else of interest. Oh, so Senate Bill 2107 is the mandatory minimums bill. And I don't know if everyone's had a chance to look at that a little bit, but it adds a number of mandatory minimum sentences for various offenses and adds some additional individuals who cannot possess firearms, which my understanding is it tracks the federal statute.
That had a hearing already, right, Sarah?
It did.
Yeah, Attorney General appeared.
Yes.
For a lengthy amount of time, is my understanding.
Yes.
Did it pass?
It has not been voted on.
They appointed a subcommittee, is that my
Yes.
understanding?
Correct. So the subcommittee consists of representatives or senators Paulson, Myrdal, and Braunberger. And Paulson used to be in the House of Representatives, has now moved to the Senate. Braunberger is new. So more to come on that one. But yeah, Drew Wrigley testified. The hearing was set for the morning, and there was kind of a snafu with getting someone from the AG's office down to talk about it. Travis Fink did testify in opposition. The fact that studies show that mandatory minimums don't work and that it would take discretion away from the judges. And of course, the argument on the other side of that is that the judge can deviate, but has to provide in writing. And Attorney General Wrigley, his comment was, well, if judges are proud to let these people out, then they should put it in writing. So.
Does that require a fiscal note?
There wasn't a fiscal note, but I believe one will be coming. Because that was discussed too. So I think that will be coming from the DOCR.
And I think it's consecutive. Didn't it say consecutive? So if there's
yes
charges, yeah.
Yep, it has to be consecutive to the other charges. So
I don't really take a position on this bill, but I do think that it would affect the DOCR's policies more than the judicial policies, because the DOCR is who is letting people out early, and not probably for good reasons. I'm not going to second guess what they're doing, but.
Well, definitely, I mean, it's going to take up more space. So, and right now, so DOCR testified that women's prison is at 100% capacity and the men's prison is at 96% capacity. So.
Do you recall what the crimes are with the mandatory minimums? It's gun related, some drug related, and like related?
Fleeing the police. Let me pull it up.
The bottom of page 7 starts with possession of a firearm in relation to a felony crime of violence or drug trafficking crime.
Yeah. So, I mean, there's a number of them: preventing arrest or discharge of other duties, simple assault, shooting at an inhabited dwelling or camper or occupied structure, fleeing or attempting to elude a police officer. And then, oh, go ahead.
Oh, I'm sorry. I didn't mean to interrupt, Sarah. Sorry.
It's okay.
I think it is also interesting to know 85% rule would apply as well. So it is is really quite a change from where we're at right now.
Yeah, so, I mean, it'll be more people taking up space in the jails.
Judge Eltwig, by that,
prisons.
do you mean that the parole board could release them earlier than 85%?
No, I think if you look at bottom of page 8 on that draft, an offender is convicted of a crime under this section is not eligible for release from confinement on any basis until 85% of their sentence imposed by the court has been served or the sentence is commuted.
Okay, I see that now. Thanks.
Yep.
Can you see my screen now? The
Yes.
bill should be up.
Yes.
So yeah, people will be going for a lot longer than currently, so. So I'll keep
Or
an
they'd
eye
be
on
effectively deterred to no longer commit crimes. I think that's what the Attorney General said.
that. What?
I missed that part. 4A, term of imprisonment imposed on a person under this section may not run concurrently with any other term of imprisonment imposed. That is going to create a lot of jury work.
You know, one thing I'd like to ask the committee, our committee here is I know Justice Tufte, you probably, well, you're our most tenured member of this committee. Is this typically, you know, this is more of a substantive law type of situation. Is this something that we typically have any way in on? Because it doesn't, I mean, I suppose it does have a lot to do and a lot to say about court administration, but I don't know if this is something we typically enter into or not.
Normally we wouldn't. We would, and if I think the farthest we would probably go, at least under our past practices, would be that the judges are exercising their discretion appropriately, and can the Attorney General, for example, point to any cases where he feels like the sentence was too short? I mean, I don't know if we want to engage in that debate, because he'll find a few, I'm sure, that probably won't look like they were long enough sentences. But on the substance of should the penalty be this big, generally that's not been viewed as our role here.
Yeah.
And so we just, if they want to pile us up with work or you know, change the standards, our job is just to interpret and apply those standards, I think.
Yeah, and no, that's a good point. I appreciate knowing that. And one of the things with the point that we may go as far as is, you know, if you look at the deviation report every year, it's been, I think, some years now since there's been one reported. So that actually may be a good point to make if it ever comes to pass that we have to defend ourselves as the judiciary. So
I know Travis Fink pointed out that judges typically do not deviate. And that he also pointed out that this is going to lead to more jury trials because there's not going to be any benefit to entering into a plea agreement when you have a minimum that you have to serve and it's going to be consecutive. And so.
Yeah, I wonder how many offenders the parole board is releasing that used firearms related to crimes of violence. That's almost the same argument that we would make, that they might have some thoughts on too.
Mm-hmm.
Are we getting a feeling, Sarah, if it's going to pass or not, or do you know?
Not at this point. I don't know.
Yeah, so I mean, if there's technical issues you see or flaws in sort of the structure or how the parts work together, sometimes we can offer that sort of comment, but generally we don't have significant credibility or appropriate role to weigh in on the substance.
I agree with that. My job is either.
Well, good to know.
Yeah, so
With this sort of statute, I think, and just to close this up, I think what this leads to in the federal system is a lot of charge bargaining where they allege a gun to have the big hammer of the mandatory minimum. And then if you plead guilty to the underlying crime of violence, we'll withdraw the allegation of the firearm to remove the mandatory, and then they can make a deal. And so that's why even more cases plead in the federal system than the state, because of those kinds of bargaining techniques.
Well, I guess we'll find out if it passes, if that's how things work. I see Judge Matson is joining us.
Welcome, Judge Madsen. Are you with us by audio yet?
You're muted.
Okay. Good
We-
afternoon.
Hey.
Sorry for the delay.
Yes, thank you for joining us. Sarah, Ms. Behrens, should we switch back to the restitution discussion now that we're all here?
Yes, so the other bill of ours that was up was 1041, which is the restitution bill. And that did not go as I thought it would. So let me pull that one up. Okay. So Representative Clemene had a lot of questions and comments on this one. So let me just grab my notes. Okay, so first, he's concerned about the timing for the victim to provide the information to the prosecutor, that there isn't a time frame for that. So, and it's kind of difficult. I did have one thought. I know, so, I mean, there's going to be this period of time that it's open after they'll be held open for restitution. Thoughts on giving the victim that 60 days that the prosecutor has. So and instead of like putting a time frame for the victim to provide that information, just saying after that 60-day time period, the victim can no longer submit information. So both the prosecutor and the victim have that 60 days, and that 60 days then passes, and that info, whatever they have, has to be sent to the defendant.
What confused me about this the entire time is the case gets charged out and the prosecutor should be sending a letter to the victim when it's charged out. By the time it gets to sentencing or after trial, there's been 3-6 months in most cases. So the victim already has that initial 3-6 months, and now we're going to give them 60 more days. I know when I was in Cass, Judge Webb made us have restitution at the time of the sentencing hearing or set it for a sentencing hearing at a later date when it's ready. I'm confused why we would give more and more time after sentencing when it's the prosecutor's job at the beginning of the case, but that's my thoughts.
Generally, I would agree with Judge Clark, but where I'd have a point of going down a different path is when we're dealing with medical issues, because sometimes the hospitals or treatment providers just are really slow, and that I can even run faster than them. But so from that standpoint, I would look for something, an added time for medical related expenses. But other than that, I would try and dovetail with what is out there already. They are different in that, and if a victim only has to submit it to the prosecutor and they do it on the 60th day, it's not the only case for the prosecutor. They have multiple cases. I mean, that's kind of a growth industry in this state in terms of victim witness coordinator.
Judge Manson, but and tell me if I'm wrong, couldn't the prosecutor ask for a continuation of the sentencing hearing because they haven't received all the medical restitution amounts yet, though? Because that's
Well,
the trigger is the sentencing hearing, right?
It should come in, but oftentimes it doesn't, in that we hold jurisdiction open for 60 days or 90 days on the victim witness, or excuse me, on the victim's damages type of a thing. But we'll go forward with sentencing. And that, and we'll just hold it open for restitution claim, whether it be 60 or 90 days. These are assorted thoughts. I don't know. Is it more concise, Sarah? Have you had more of a concise point of view from what Flamine had indicated?
Say that again.
Okay. I've just kind of spit out a bunch of
Okay.
assorted thoughts. They aren't concise in that. And I'm wondering about with Flamine's concerns in that, is it more focused in that in terms of whether what he voiced on his concerns or with what you've have been seeing or listening?
What he wants is he wanted a defined time that the victim has to provide that information to the prosecutor. So even if it were, 30 days after the sentencing hearing, and then after that 30 days, then they can't keep providing information. But then I don't know why the prosecutor would need another 30 days to provide that to the defendant, but I've never been a prosecutor, so I don't know.
Well, to Judge Madsen's point with respect to the medical records in light of, Marcy's law, the right to full and timely restitution, you may run into problems with full restitution if by the time that case winds up, you don't have a full amount of what the full amount of restitution is. So I think you may run, putting any kind of time limits on that may run afoul of Marcy's law. So
if I can jump in here a little bit, one thing that I think the committee, including the chairman Kameen, were struggling with is not sort of appreciating that the judgment typically closes the case with finality, and this is an exception to finality of judgment, starting the time to appeal and putting an end to a matter. And so I don't think he appreciated the first part of that subsection 2, that if the court retained jurisdiction, he kind of had in his mind that some period after judgment, the victim could still come in, submit information, and get restitution added. And I think a lot of defendants would probably be pretty surprised if the court had not retained jurisdiction for that purpose. And so maybe you district judges can speak to it, but the district courts never retain jurisdiction without a time limit, do they?
No, I mean,
No.
how I do it is, I mean, as soon as like they enter guilty and if there's a plea, for me, I take it as the moment they say guilty, you've got 60 days to get restitution if it's requested. Otherwise, it's closed, because there has to be finality for an appeal if they want to appeal for whatever reason.
And if it drags more than 60 days, we're going to get more criminal cases with 2 appeals, one for the initial sentence, one for the restitution later.
And again, I just kind of go back to my old point. The prosecutor should be asking for continuance of the sentencing hearing because due to the fact that they don't have full restitution, because the defendant, it needs to knowingly and voluntarily plead to this and know what his restitution amount is going to be. I think that it should be, the onus should be on the prosecutor's office to get this all situated and done before the sentencing hearing. And then, yes, I always retain jurisdiction for 60 or 90 days.
Well, and that's the point I think maybe that Clemene is struggling with is there isn't, Mike, Judge Hurley says 60 days, Judge Clark's 90 days, I'm typically 90 days, and that there's no uniformity there. I don't know if that's, if that really makes much of a difference or not, but it doesn't seem to me there's any uniformity across the state of how long a district court retains jurisdiction on a restitution matter. Yeah,
and Sarah and I talked about it. I thought I had, and maybe I'll just throw it out there for consideration by those of you that are in the trial courts. Given that the court sets a deadline, I don't think we need to impose uniformity, but I think it would help Chairman Clemene understand that there is a deadline in the judgment in which the court states that it's retaining jurisdiction, that there's always a deadline. So we just need to say the victim shall, within the period the court has retained jurisdiction, submit information by affidavit, so that it's clear in this first sentence that the deadline is whatever the court said when it retained jurisdiction.
That's
But-
beautiful.
I agree.
I have a question about that. So if the court retains jurisdiction for 60 days and the victim submits their information on day 60, then the prosecutor provides the information to the defendant, and then the defendant has another 30 days. Aren't we past the time that jurisdiction was retained?
When I retain jurisdiction, I say for a stipulation or a hearing to be set within the 60-day period. So sometimes it's out of the 60-day period, but they've set the hearing to complicate things even more.
And that makes sense. That's the way that we've done it. Either you guys come to an agreement on what the restitution is, and if not, then there has to be a request for a restitution hearing in X number of days.
Yeah, in essence, I think I run it the same way as the other two folks. Is the initial 60 or 90 days, that is a triggering event, and so if that is the time limit in essence, where if there's nothing filed within 90 days, this judgment is final and we're all done. If there is, then yes, I guess a new set of time periods come into effect. And so there is some time periods. It's in the discretion of the court, but I don't think it goes on forever and ever. And that might address Clemine's objections. I don't know.
Justice Tufty, I think the language that you threw out works as long as it recognizes that, with what Judge Clark had indicated, you either have an agreement or you have set it for a hearing within that time frame. Would that cover Clemine's concerns?
I don't know if that works with the other language we have, though, because we're saying that the defendant has to request a hearing.
Well, the defendant, if there's no agreement, the state is generally the one that has to request a hearing then, if they're the ones that are seeking restitution.
But that's not how we have it written right now. Can you still see my screen?
Yeah.
Okay,
Are we
so
in paragraph 2?
paragraph 2 is where it talks about retaining jurisdiction. The victim has to provide the information. The prosecutor then shall serve the defendant with the information no later than 60 days following sentencing. And then the defendant may challenge restitution, but must do so by requesting a hearing within 30 days of being served with the written notification of the amount of restitution requested.
We have to rework that paragraph then.
Well, it sounds like it doesn't work unless the retained jurisdiction is for 90 days or more. That
Yeah.
would make it work.
So at sentencing, the court has to expressly retain jurisdiction. And if not, then
That's
we're done.
final. Yeah, that's the main thing that I think we weren't communicating to the committee very well, is that the judgment's final unless jurisdiction's retained, and the victim can't walk in any period of time later and try to get it reopened for restitution.
And that's pretty much the way it is right now.
Yeah, I don't know if we're making progress on this yet or not.
I think so. Well, see, I may speak because I understand what Cherie Clark is saying, is that Judge Clark is, I don't understand, I've got a really good prosecutor, and I can't speak for the other prosecutors, but I don't, and as what Judge Madsen said, is that there's a cottage industry of victim witness advocates, that they would not have that information to the prosecutor even before sentencing. I have not yet seen that. That's okay. I'm
just be envious. You lead a charmed life.
Well, okay, okay, I will. And the only time I've ever run across it is when they show up and they plead guilty right then and there, and then it like, well,
Exactly. That right. I mean, the prosecutor should be getting that letter out when they charge the case. In Cass County, we would say, get this back to us within 14 days. But that's not how this bill is written. So
I'm wondering if we need to rewrite this paragraph then and say the prosecutor has to get this to the defendant before sentencing, and then after that, there has to be hearing within 90 days or whatever. And if it's not asked or requested, then it's done, because there has to be finality for everyone aboard. And the other thing is, I understand the medical issue, but at the same time, those medical issues could be ongoing for the rest of that victim's life. So regardless, there has to be some finality so there can be an appeal if the defendant wishes to appeal for whatever reason.
Sarah, can I ask a question? Under paragraph 2, it does say if the court has retained jurisdiction for the claim of restitution. Why doesn't that line right there tell him that the court first has to retain jurisdiction? Should we say for a specific period of time, or?
I don't know. I guess I didn't I didn't catch that he didn't get that.
May I ask you, Sarah, may I ask a question? Was there anyone there from the State's Attorneys Association?
No.
Do they have an identified lobbyist?
Aaron Burst.
I'm wondering if Aaron may have language. Kind of present this to him on what they would view as workable.
Yeah, Travis Fink was there. Did you talk to him at all?
He doesn't love this bill, mostly because of requiring the defendant to request a hearing.
Yeah, well, that's the main thing we're trying to fix is the mandatory hearing. So
that was his issue with it. That I talked to him before the hearing, so I don't know. And I believe he left before that hearing was over.
I could see if he had a point before Marsley's Law, but now there's no more ability to pay, and there's that. So it's the victim gets restitution, and now we're just trying to stop hearings or to make a mechanism that works. But I agree that we should maybe present this to Mr. Burst and see what he thinks.
I think that's a good idea.
yeah, are you able to do that, Sarah? Maybe talk to both Travis Fink and Aaron Burst to just see if they have any suggestions based on the discussion we've had so far.
Mm-hmm.
Can we visit on this next week then?
Yeah, I don't know when they plan to talk about it again, because I know the legislative intern was asking about getting our thoughts on some amendments that they suggested by tonight, so we can have them ready for Monday morning. But
Oh, wow.
yeah, so I don't know. But we're not going to be able to work this part out by then with
Let
other people.
May I suggest you let the intern know that we're trying to consult with the state's attorneys and the public defenders people?
Yep. You want to talk about the other issues raised?
Yeah, if you just let us know what the intern suggested, and then we can get the committee's thoughts on that.
Okay. So let's see. So there was a victim who testified, and he owns the New Freedom Center, I believe, in Mandan, so the Alcohol and Drug Treatment Center. And he had an employee who embezzled lots of money. And apparently this defendant now makes $93,000 a year, but is only paying like $200 a month on this restitution, and he's really frustrated with it. And his suggestion was that we use forms like the federal court does to get all this income and expense information from the defendant so that the court knows how much the defendant makes. I think that will bring Marcy's Law issues. And I think that the intern understands that. He talked to Chris Joseph, and I think they understand that there'll be Marcy's Law implications there. So
I don't know Marcy's Law implications. What do you mean?
because you can't consider the defendant's income anymore. The victim gets full restitution. His situation is different. I mean, he actually has a defendant who has money. That's
Right.
not going to be the case usually.
Yeah.
Typically, getting that income info, you're going to see, oh, this defendant doesn't make anything. Well, you can't say, well, then their restitution is going to be less. So it would
He's
be
just wanting us
more.
to take into account for payments, right? Don't do 200 if you're making $92,000 a year. Do 500, 600.
Right. And my understanding is that we aren't setting payment plans, that the probation does.
I do.
You set, oh, okay.
I do.
My experience in the Southeast District was the judge often set the payment plan.
Okay. I don't think that's always happening.
I don't. I defer over to probation parole, taking advantage of some of their language. And
Yeah.
The reason I don't is because I know at the end of probation, what all they're doing is reducing it to civil judgment. So if there's a restitution amount, I set a payment schedule, even though they're on supervised probation.
I will not set anything for civil judgment in that it deprives the children of North Dakota their education dollars. In that it's a rare day that I do that. Rather, we have ordered show cause hearings, and we'll be bringing them in after judgment in that. So in any event, what I'm wondering about that particular victim, Sarah, wouldn't that individual have the ability to go to civil court?
He already did.
Okay.
He's garnishing wages already. So he's frustrated. I get that, but I don't know that there's anything we can really put here that would have remedied his situation. Because I believe in the civil matter he has, they submitted like his income. So I don't know. It would, I mean, if judges are going to set payment plans, it might be helpful. But since they don't always, and probation often does. And like I said, I mean, typically you're not going to have money available. So it's usually going to be setting up orders to show cause at some point anyways.
And probation's not going to revoke for non-payment of fines, fees, or restitution.
Well, apparently they did in that case. They revoked for failure to pay restitution.
Yeah, he had a deferred imposition of sentence and they revoked it.
Probably,
But
And
I think that's,
he had an
Oh.
ability to pay if he's making $92,000 a year.
yeah. So,
So maybe the South Central District doesn't do orders to show cause hearings, because the other suggestion this Ari Sadot had was to mandate annual reviews to ensure adequate effort in paying restitution to make meaningful progress. And that sounds even more onerous than the guardianship reviews and other mandatory reviews we have.
Yes and no, in that we do them pretty regularly, where they'll come in, and if they haven't been paying, the clerk's office will notify and we'll be bringing them in. And if they don't come in, then they're subject to a bench warrant. But
Okay. So that's a matter of routine. The clerk's office handles that up in Northeast, North Central.
North
Yeah,
Central, yeah.
I did a survey from the various trial court administrators, and that's Carolyn Probst let me know that in Ward, Burke, McKenzie, Montreal, Williams, supervised probation cases, the probation agent monitors it and seeks action from the state's attorney. In unsupervised cases, the clerk monitors and does an order to show cause. Divide monitors all restitution, sets up the OSCs. There seems to be kind of a mishmash of that. So a lot of times, the clerks will somewhat monitor it and send or set up order show cause. Sometimes they send a report to the state's attorney, and the state's attorney will, request an order to show cause. So it kind of depends on the jurisdiction.
And resources available to the jurisdiction. What do you want to do, Mr. Chairman?
The only thought I had there, because I mean, it doesn't sound like it would be that large of a burden to have something like this mandatory annual review that he suggests, but it sounds to me like many of our districts are already doing that more frequently than annually. And his problem is that whoever set the payment plan set it too low. And so he was in compliance with his payment plan. And there was, the review that we're doing is, are you meeting the payment plan? Not, are you making meaningful progress to get to full restitution? And are you paying within your means? That's more his problem. And so I thought if we had a provision added that gave the district court discretion, and I'll acknowledge up front, the district court probably already has this discretion, but gave the district court discretion to require the defendant to submit, net worth and income and asset type information for the purposes of setting a payment plan, or maybe require the defendant to submit that to parole and probation for the same purpose. That would reach the issue that this particular constituent who testified was having a problem, is that this guy had 500,000 in restitution and was making 90-some thousand a year, and he wasn't paying anywhere near what most people would think was reasonable.
I understand that. I almost fear that that's the exception and not the rule, because the general rule that we get is I have no money and that I have no assets, but I have these debts and everything like that. But yet we still get payments from these people on a regular basis. So these financial affidavits that we get, even when you look at it for application for court-appointed counsel, and I do look at that at sentencing time when I'm being told certain things. A lot of those financial affidavits, and the other judges can correct me, but I mean, it seems like that all you see is these either NA or these lines through, different categories of assets. And NA, I view it to be non-applicable, not non-alcoholic beer. But so I don't know where we would get, how much further we would get, Justice, is the point I'm trying to make on requiring a financial affidavit.
And who would review them, and how would it get? I mean, if they're on supervised probation, how would it get to the court? And the process, I'm not sure how that would work.
I think you'd either.
Go ahead, Sarah. I'm sorry.
I was just going to mention, since it sounds like in some of those counties, when it's supervised probation, then parole and probation is monitoring that. So maybe that info would go to them to set the payment plan. And if it's unsupervised, it would go to the court to set the payment plan.
Yeah.
We should be doing that sentencing, though. I'm confused.
The problem with the finance, I know, and we see it in injured defense applications. You have zeros and NAs and everything. And I was on another committee many years ago about, how do we verify any of these numbers? And, they're brought into a lot of doubt. We talked about doing eligibility workers and all the rest of it. Unfortunately, unless we have some investigative arm to look into these applications, we're kind of stuck with their numbers. So I don't know how meaningful any of these kinds of affidavits are a lot of times.
the probation officer really isn't the best. I mean, they're requiring him to have a job anyways under Appendix A, and then they know they work, but I've never seen a probation officer who enforces payment until the end.
Sounds like it's different everywhere. And I don't know if there's an answer. I just don't know if there's an answer to this problem. As far as the restitution, because if a gentleman is paying, he's not in contempt of court because he's paying what he's supposed to pay.
Yeah.
Well, they still revoked him.
Okay.
The risk here is that they'll offer an amendment that's going to make things work less well than they do now in most cases, or provide a lot of burden without much corresponding benefit. I know we need to talk to this legislative intern a little bit more. Anybody have any suggestions for what we can offer that would maybe sound like it helps, and maybe help in some of these outlier cases where the person does have money? I don't know.
Yeah.
The judge should inquire at sentencing what his income is and set an appropriate repayment plan for restitution, and not defer to the DOCR and probation officer.
I would agree, but did this guy have, or defendant have, that job at time of sentencing, or was it something that was gained later?
It looked like he had that job at this time of sentencing, from what I could tell.
And was it a Rule 11 where that was a stipulated term in the Rule 11, or was the judge free to do what the judge wanted to do?
I don't recall.
Do probation officers ever ask for tax returns or anything like that? That could work.
I don't think so.
That's a great one. And but I think they're going to have statutory authority for that.
And we're assuming people that are under probation supervision file taxes timely with the Internal Revenue Service, and consistently.
Or
They're
have
obligated
jobs
to.
for longer than, or have jobs for longer.
Right.
Days.
Could you revoke somebody for not filing their taxes on time in violation of federal law?
Well, it is a violation of federal law. Yeah.
So they probably better be filing timely then, huh?
Yeah.
All laws. I mean, that's a good point. Think about that. Yeah.
And you'd want to make sure parole and probation was keeping that kind of sensitive information confidential, but they deal with confidential information all the time. So that might be something to talk about with this intern anyway, Sarah.
Okay. So when parole and probation sets this payment plan, can they change that then midstream? I don't know how they do those.
Yeah.
Parole and
Because if-
probation still has jurisdiction. I would think they could be able to change it.
Because if they got a higher paying job or they won the lottery or something.
So the judgment sets the total amount of probation, and Judge Mattson, your Appendix A just says on a schedule as set by parole and probation.
Yep. And so they have jurisdiction. They can be able to move it around.
Yeah, because they're going to be in a better position to know what their financial picture is than I ever will, and they'll know it much faster than I might ever.
I think the other thing is, because I know I've done it sometimes, I haven't done it all the time, but as a condition of probation, you pay the restitution off by the time probation is over. So
Yeah.
but it would be $500,000. I mean, that's probably unrealistic even for.
You want to see meaningful progress is ultimately.
But what I'm wondering about with the comments that have been made, kind of a blending of what Judge Clark had said of entering up a payment schedule at sentencing, and then leaving it to be amended or changed by probation parole as appropriate.
Do you have a meeting time set yet with this person, Sarah?
No, I was going to talk to him after we had this meeting.
Okay. Judge Hurley, what do you got going on this afternoon? I thought I might join Ms. Behrens, if it's not during an argument that we
I
have.
was gonna have a late lunch with someone and then head home.
Yeah, don't worry
That's
about
what you get. That's what you get, Mike, for showing up in person.
it.
That's
I'm
okay.
not Mike.
I'm having fun down here.
You had a long drive. It's good.
Hey, he should
Ju-
feel honored.
Justice Tufty, what time are your arguments? What time are you done?
We have a 1:30 argument. I'm out of the second argument, so I should be done by about 2:30.
Okay. I will see if he's available after 2:30.
Okay. All right, well, we are at 12:51. Maybe can you, and I know you'll send out an email about what's coming up next week, but do you know of anything that you're going to need the committee's guidance on testimony?
Last I looked, there weren't many that had been put out there yet. Let's see.
Is the hearing calendar at all published yet?
They put some on the tracking deal, but the last I looked, the schedule wasn't up. Let's see, there's the mental health diversion pilot program, the mass murder statute, the sealing a criminal record, which that one, they want to seal disorderly conduct convictions now, as long as in 5 years you haven't had another disorderly conduct conviction.
This is one of those automatic seals.
This one will require a motion, but then it's also a shall.
uh-huh.
So as long as they haven't had another disorderly conduct conviction, it's a shall. So that just seems weird to me that it would be, so it's if an individual pleads guilty or is found guilty of a first offense under this section, so a first offense, disorderly conduct, and a judgment of guilty is entered, a court upon motion shall seal the court record of that conviction if the person is not subsequently convicted within 5 years of an additional offense under this section. Once sealed, the court record may not be opened even by order of the court.
So you're saying an additional offense that's just not disorderly conduct then, under that language. The other
Yeah,
question
it would
is,
have to be another disorderly. So you could commit murder and your disorderly would still get sealed.
and what do they mean by seal? Do they have, it seems that the word seal has multiple meanings across the state right now.
Well, it has different meanings depending on the restriction level that's given on Odyssey through IT. There are different levels. So whichever one,
Wasn't Sarah, it seems to me this is deja vu, but some other committee that I'm on, and I don't remember which, didn't we have a discussion how the seal language is
sealed and expunged.
right, and those aren't really meaningful anymore because we don't have physical files.
Right. Well, expunged really isn't.
Yeah. Mhm.
But sealed, it's a matter of who has access to it.
I suppose.
On the case management system. So it would be a matter of what level of security is put on that. And if it's sealed and can't be opened even by order of the court, that's going to be, maybe a different level.
Is there, as far as you know, Sarah, and I'm sorry I'm putting you on the spot, is there any other kind of sealing that cannot be reopened even by order of the court? I mean, that just seems over the top.
I want to say that there is.
I was just kind of curious because it just seems to me that by order of it's even the court can't reopen it for any reason. And there is, it doesn't much matter, but I just thought that was interesting language. But.
I don't really understand where's this one coming from. Why'd we pick disorderly conduct as the crime that you should?
Well, if you had a fight at the Down Under when you were an undergraduate in Grand Forks, you sure don't want that following you, I guess.
Did this happen?
Or criminal trespass. Or
Yeah.
no, I mean, why disorderly conduct? Like that? Does that happen more often than other crimes? Or
It's so specific, Dan.
Well, I wasn't involved. I'll tell you that much.
Oh,
Right?
I see. Yeah,
So,
you're a victim of circumstance.
yeah, I wasn't even that, but I know of people involved in things like that. So,
So Sarah, would that
Yeah.
Yeah.
would that get in the way of me? If I had a commercial data mining company that I picked up people's criminal records and I had Dan's conviction for disorderly conduct, could I not circulate that later after he's had his 5 years of clean living?
If you're the company,
Yeah. So I mean, it could still be commercially
yeah,
available.
it can,
right?
you
right.
already
Yeah,
already-
it's out there. But if someone's doing a background check, it wouldn't show up on that.
If they only
Like
go
if they're
for government-
doing, if they're doing a public records check and it's not gonna pop up.
a government records check, but if they do a
Mm.
public records check on the internet, because we know
Oh,
everything
well,
on
yeah,
the,
if they just Googled someone, then
Yeah.
they could probably still find it. I mean, there's no control over that, so. But I'll listen to that hearing and see what the reasoning is. I saw that it was only if they have another disorderly conduct conviction. I thought that was odd. That it wouldn't be any. Because I feel like usually it's as long as you don't have any other convictions, then you can get this sealed. But, so that one's up. Our parenting investigator bill is up. And then it hasn't been scheduled yet, but our open meetings bill, I know Jack McDonald is planning to oppose that. So
based on what?
transparency.
He
I'll try
wants to. He wants to go to judges' meetings.
No, well, I don't think so. No, I think he's concerned that it's too broad and that we're going to be closing all our meetings, like all our committee meetings and such.
Yeah, I'll talk to him about that. I don't know that he understands the reasoning behind it.
Yeah.
See if I can prevent him from killing a second one of my ideas this session.
So that one's not on the schedule yet, but I mean, it could end up on the schedule for next week. So just wanted to mention that. Otherwise, I think that's most everything for now.
Anything from any members of the committee before we adjourn?
Thank you, Sarah, for the work.
Yeah,
Yes.
you do a lot of work, Sarah, and it's appreciated. Thank you.
I was just caught off guard by how quickly all these hearings were scheduled this session, because I feel like in previous sessions, that first week was pretty easy going, but nope.
are they
So,
meeting 5 days a week?
yes, but the committees that we usually have stuff in meet Monday, Tuesday, Wednesday.
Committees, okay. And then I just wondered if they were looking at going an off day in also. My apologies.
Not that I know of. I don't think so.
Well, thank you, Sarah, for the work you do. Thank you, Justice Tufty and other members. And that I gotta get back into court. No, thanks so much. Bye.
Everyone. We will adjourn. You can kill the live stream and